This is Granada. Well, the drama continues in Return to Eden at 9 o'clock, but first, Scales of Justice.
It was like the sort of domestic circumstances that you'd only find in the very grandest aristocratic houses in this country. The day would start with the sort of cliche situation of the butler coming in with the ironed copy of the Times. And breakfast was like a sort of long-running Monty Python sketch because everybody would be robed for it. So you might have, say, 3 judges all sitting there fighting over the marmalade in their full court robes. And then when breakfast was over, you would all line up. The staff would assemble in a sort of Victorian manner to wish you goodbye. They're living at the taxpayer's expense for 6 months of the year. That's one of the perks of the job, because the kind of lawyer who would be promoted to the judiciary would be the kind of lawyer who had a very substantial practice. And that means lots of money. So he takes a drop in income, but the compensating factor is that he gets a knighthood, his wife becomes Lady So-and-so.
The ceremonial opening of a judge's circuit at Lincoln Cathedral. The tradition of the English judge making a provincial circuit to try cases dates back centuries. En route, they stay in gracious homes, attended by an entourage of chefs, butlers and marshals.
It is a somewhat isolating life, because we live really rather a cloistered existence. I think you have to be careful to keep yourself apart, because otherwise I think life would be extremely difficult. There have been occasions when even a trip to the local supermarket has had its hazards.
I think it is often said that judges, as it were, live in ivory towers and don't know what's going on, don't know what the ordinary man on the street thinks, and don't know what politicians are about. I think this is wrong. I think it's nonsense. These are very intelligent men. They are not politically naive. In fact, I suspect that senior judges very frequently know a great deal more about political realities behind political decisions than you or I do.
The English judge matches the stereotype of being male, white and middle class. At the top 114, only 3 are women. None is black. 70% went to public school. They are virtually unsackable and need not retire before the age of 75. They are prized as impartial dispensers of justice, independent of state and politicians. But judges are chosen by a party politician, a cabinet minister, the Lord Chancellor. Lord Hailsham, the present incumbent, is 80 next year. His father before him was Lord Chancellor. Lord Hailsham enjoys a formidable patronage. More than 60% of our leading judges owe their appointment to him during his tenure of the Woolsack.
The system of appointing judges is unsatisfactory. It is quite wrong that the power should lie totally in the hands of one man.
The Lord Chancellor does not like his judges appearing on television. His department abruptly ceased cooperation with this programme when we refused to give an undertaking that no judge would appear against Lord Hailsham's wishes. Lord Templeman is a judge who does not feel bound by the Lord Chancellor. He's a law lord, one of the country's top 9 judges.
Now, I think there are some people who are interested, first of all, in seeing what a law lord looks like.
because all they know is that we have 9 elderly gentlemen who sit up and pontificate from time to time.
Law lords are chosen by 2 party politicians, the Lord Chancellor and the Prime Minister.
The decision is certainly made by 2 party politicians, but I don't think, certainly in my time, there has never been a political appointment. Judges will try and insulate themselves entirely from politics, and that's because a High Court judge in particular will almost certainly at some time in the course of his career have to make decisions for and against cabinet ministers, local authorities, trade unions, big international companies. And therefore, the less emotionally involved he is with politics, the better. A revolutionary judge is a contradiction in terms.
The Lord Chancellor chooses judges through a grapevine, a system of secret recommendations by barristers, judges and civil servants.
In the end of the day, I would think probably the system will have to be formalised. And the weakness is this, that although the system works well, the consultations which the Lord Chancellor carries out are confidential and informal. There are over 5,000 barristers, there are about 300 circuit judges and about just over 100 High Court judges. And that means that a large number of barristers are not going to get appointments to the bench. And occasionally one will wonder whether he hasn't been blackballed.
Manus Noonan believes he was blackballed. As a part-time judge, a recorder, he was interviewed by a Lord Chancellor's official for possible promotion and extra judicial sittings.
He said that I was a person of the highest professional standards and a person of total integrity. As well as that, he said there were some debits that I was a bit unpredictable and a bit theatrical sometimes, and somewhat impatient. But it was an extremely friendly interview.
On October the 11th, 1984, the extra judicial sittings were ruled out on the grounds of expense. Still, Manus Noonan saw the renewal of his recordership as a formality. Shortly after, 160 other recorders were reappointed, but not Manus Noonan.
The date is significant. It is, I think, tolerably obvious that a decision was taken against me between the date of that letter and the date when renewal notices went out to other recorders.
Between the 2 dates was the IRA's attempt at Brighton to assassinate the British cabinet. Manus Noonan, while having served the British Crown for 20 years, is an Irish Catholic.
And it is my belief that because I was in that position, that a hasty decision was taken by Lord Hailsham against me. I am informed on very good authority that he personally took that decision.
The Lord Chancellor denied prejudice, eventually giving his reason as substantial adverse reports by a significant number of circuit judges.
The senior judges on my circuit have told me they know nothing at all of this. In fact, there is not a word of truth in it. How can it be that there was nothing wrong with me on the 11th of October, and within 10 days or so, judges are complaining against me and I'm unsuitable for judicial office? It's a nonsense from beginning to end.
Well, I think all barristers hope that they will finish up on the bench. I think there is a natural tendency to look for the security. And on the particular day in question, instead of going to the front door and being a barrister, I went to the back door and was immediately called Your Honour. I then almost instantly became the judge.
Her Honour Nancy Wilkins sat as a deputy judge and recorder irreproachably for 10 years. But just as she expected promotion, she was mysteriously passed over.
Nobody had expressed any misgivings about my abilities. Indeed, I was very much in demand. And I caused inquiries to be made, and I received a very disappointing answer that my prospects were not encouraging, and that it was suggested in terms that if I had any options elsewhere abroad, I might be advised to take them up.
No reason has ever been given to her.
I suspect it's partly because I'm a woman. I think that they probably concluded that I was a little too militant, because I do care passionately about the system, particularly about the family courts, and I did have quite a lot to say behind the scenes to try and improve the service that was given ultimately to the people on the receiving end, these people who were going through the agony of a breakup of a marriage. And I always felt that the civil servants, the upper civil servants, not the actual clerks in the courts, didn't pay sufficient regard to the fact that these were real people who really should have had a good service from the courts and a good service from the judges.
It is frightening that the present system should exist. In dealing with these officials in the Lord Chancellor's office, I felt that I was not dealing with British officials at all, acting on proper principles. It was like dealing with functionaries in an Oriental court.
Well, I couldn't even guess what sort of criteria they apply, because this is really one of my complaints, that we can only surmise about what they're looking for in their appointments. It does seem that they're looking for people who are going to be conventional, people who are not going to cause them any trouble, people who are not going to rock the boat, and people who are going to be virtually time servers and make their lives as easy as it possibly could be. I don't think they want controversial judges, and I don't think they want people who are going to try, for whatever motives, to improve the system.
The judge's duty is to enforce the existing law, and although occasionally, particularly with procedure, he may be able to make what he thinks are tiny improvements, it's not his job to make the law, it's not his job to break the law, and inevitably I think most judges are conservative with a small c, but it's not for them to take any views, and it would, I think, cause chaos if they did attempt to take political views. They're not political animals.
They have choices to make, which are generally said to be choices where the public interest lies. And in my definition, where the public interest lies is a political question.
In no case have the judges and politics clashed more bitterly than in the GLC Fair's Fair case.
This was a classic case, if you like, of genuine interference in an area of high political content.
In 1981, the Labour Party and Ken Livingstone swept to power at the GLC on a platform of cutting London transport fares by a quarter while putting up the rates. But Bromley Council took them to the High Court, claiming the GLC was acting illegally. The GLC won, but it was a brief success.
For us, I mean, the real shock was having won in the High Court and the judges ruling that we were entitled to cut fares, to go into the Court of Appeal and have these incredible judgments. I mean, one of our lawyers came back to me in a state of shock, saying it was like sitting through a party political broadcast.
The court said Londoners who had voted for the policy would eventually suffer for it. One judge called the plan a completely uneconomic proposition done for political motives. The statutes said London Transport had to meet the needs of its passengers, be economic and balance its books, which the GLC intended to do by the rates increase. The House of Lords confirmed the appeal court decision.
It was a very bad decision. They said, in effect, they'd given too big a subsidy. Now that seems to me the sort of thing, the sort of decision, in a highly political area, the court was under no obligation whatsoever to come to and would have been far better to have stayed out of.
And we just didn't allow for the fact that the judges respond to the political climate of the day. And therefore, whatever we'd ended up in court on, my guess is that we would have lost.
Judges are recruited from a particular class of society, what one would call conservative with a small c, I think. And they are not, therefore, likely to be handing down judgments which conflict with the major interests of that group. That is the governing group. If they are mixing, as they are and always do, with the sort of politicians who make those sorts of decisions, If you ask me whether during the currency of a case 10 Downing Street ever rings up, the judge was sitting on a case and says, I think you ought to know this, the answer to that is no. I'm sure it never happens like that. If you ask me, on the other hand, are judges politically conscious and aware of the situation in which, in a particular case, the whole thing is being administered, like in the GCHQ case, for example, then I think, yes, of course they are politically aware, and I think they get to know.
The GCHQ Intelligence Gathering Centre at Cheltenham. In 1982, the government suddenly banned trade union membership from GCHQ's 7,000 employees in a case that still reverberates today. There was no discussion, no consultation. The civil service unions took the government to court and won. The judge said the government had acted against natural justice. But the government appealed with a brand new argument. To have consulted the unions, it now said, might have provoked industrial action, thereby endangering national security.
It certainly happened in the Court of Appeal that you just had to murmur national security, and that was the end of the argument. And you did get that feel, the speed with which the Court of Appeal operated, and the overwhelming nature of the reverse of the High Court decision, that here was the establishment rallying round its own.
The Cabinet Secretary finally made an affidavit to the Law Lords, asserting national security really was at stake. But the Law Lords sought no elaboration, no cross-examination, and summoned no ministers to justify the claim.
I think that in the GCHQ case, the judges simply accepted the evidence that was put before them, which I regard as highly inadequate.
If the judges had been willing to look with rather more scrutiny at the claim which the government was making to national security, they might have concluded that the claim was not as well-founded as they say it was.
The courts will always back up the state in a highly sensitive matter like national security if their discretion is under threat, because that's where they see their duty to lie.
The courts have taken a set of views in support of established authority in the major social areas: industrial relations, race relations, government secrecy, immigration.
Heathrow, the Bangladesh Airlines arrival from Dakar, known to immigration officers as a problem flight.
Bangladesh, all round here then, please. Thank you.
The series of law cases which has determined who is or isn't an illegal immigrant has shown the law and the judges at their most controversial.
See your card, please. Do you have these cards for the Bangladesh passports? Thank you.
There's no doubt at all that the intention of the legislation is racist, in that it's intended to keep out coloured immigrants rather than white immigrants.
The legislation may be racist, but how do our judges interpret it?
Frankly, the judiciary hasn't challenged that at all. At very occasional moments, there has been some sign that they might be going to, but that's never been followed through. We've not seen the sorts of changes that we would need to get justice for immigrants in Britain.
The most remarkable ruling by the Law Lords came in a case called Zamir. Mr. Zamir came quite legally to Heathrow from Pakistan. Between applying to come to Britain and his arrival, he got married. He'd been here 2 years when he was arrested. The Home Office claimed he should have told Passport Control about the marriage, even though no one had asked him. His silence, they said, made him an illegal immigrant, and all the courts agreed. He was deported.
Zamir was seen as an absolute disaster. The system that the courts chose was effectively to say that if the Home Office had good grounds for saying someone was an illegal entrant, that was the end of the matter and they had to go. It's not far removed from charging someone with murder and convicting them on the basis that there were reasonable grounds for the police to believe that you had done it, and you eliminate the trial process from it. And yet it was happening without any kind of possibility of an appeal that was in any way meaningful.
They certainly weren't incompetent. I don't think anyone would ever accuse the law lords of that. They got the law wrong, but they got the law wrong, I think, for reasons not to do with actual legal reasoning, but by virtue of a policy decision, really.
But law lords aren't supposed to make policy decisions. That's the job of Parliament. The Zamir ruling caused a furore inside the legal establishment and prompted a major campaign in the immigrant community. Within 2 years, the law lords unprecedentedly overturned their earlier decision in an identical case called Kira.
All that Kira proved was that the judiciary can respond to a coordinated and organised campaign. I don't think it showed any intrinsic shift. It simply proved that judges don't make their decision in a vacuum.
Well, the original decision was wrong, and the quicker it was corrected, the better. And so it was within 2 years. It's quite a remarkable event, and I think it says something for the judiciary that it was capable of saying, yes, we did get it wrong.
In effect, Kira was the exception which proved the general rule, which is that the judges have been making decisions which limit the basic civil rights and standards of justice which immigrants can expect.
He's from Bangladesh, yes, but he's studying at the Islamic University in Saudi Arabia. Yes, yes. He wanted to come for a holiday.
It's 5 years since the Kira case, but this year the judges have taken from immigrants one of the fundamental rights of British justice.
He should go because he is a student there.
Yes. Where is he at the moment?
He's in the detention center in the near prison.
Harmondsworth, in detention center.
Yeah, yeah.
So all I can do now is on Monday to make representations in writing to the Minister of State.
Their latest ruling denies most intending visitors and immigrants the right to be heard in court at all.
At least while this is being considered. It's ridiculous in being locked up.
Some visitors to Britain get no further than the Harmondsworth detention centre, a mile from Heathrow. Here, prospective immigrants and deportees are locked up while the authorities decide their future. Until now, if an immigrant was refused entry and thought the hearing was unjust, then there was a right of appeal. Administrative decisions in every walk of life can be challenged like this. It's called judicial review, and it's central to the idea of judges ensuring the authorities don't act unfairly. Judicial review was an invaluable remedy for many immigrants who felt they'd been treated harshly.
I think the great merit of judicial review for the man in the street is that whether he succeeds in his opposition to any decision, at least he has a chance to make himself heard.
But now, a House of Lords decision called Swati has taken away the right to judicial review.
Sometimes people could get a review of a case and heard with more respect for the normal standards of British justice than the immigration appeal system. And what the Swati case has done is basically put us back to square one.
At the moment, you cannot appeal against a refusal of entry unless you go back to the country from where you came. And of course, if you go back to the country from where you came, you're not in a position to present your appeal in any effective or meaningful way. Because people may be coming for a wedding, they may be coming for a funeral. Well, the wedding and the funeral will be past by the time they can have their right of appeal back home.
In terms of intellectual achievement, they're a very remarkable body of people, but they are remote, and it is a nonsense to say that they can actually put themselves in the position of the people who come before them. How do you know what reality is like when you wear black tie for dinner every evening?
By looking at the judgments of judges over a fairly considerable period of time, in the general field of public law, that is the law relating to public administration, to governments and so on, to perceive certain common types of decision-making. And I don't think one ought to be surprised about this. If one starts with the assumption that I have made, that the judiciary is a part of the establishment, then it is not surprising that the judiciary should support established authority.
Thank you very much.
I don't accept the criticism. Looking back at the decisions which have been made, they've, to my mind, all been questions of construction of statutes. There have been cases in which the government have been defeated. They've been defeated in the Court of Appeal. They've been defeated in the House of Lords. There have been cases in which, in government circles, the judges have been terribly unpopular. There have equally been cases where judges have been unpopular with the trade unions and with the Labour Party, and I think our decisions are fairly well spread. I don't accept that you can look through and see that judges always decide in favour of grinding the faces of the poor. I don't accept that at all.
That was the last programme in the present series.